The constitutional framework of India establishes a robust parliamentary system of governance, both at the central level and within the states. The supreme legislative body for the entire country is the Parliament of India, which is formally constituted under Article 79 of the Constitution. This article specifies that the Parliament for the Union shall consist of the President and two houses, known respectively as the Council of States, or Rajya Sabha, and the House of the People, or Lok Sabha. The President is an integral part of Parliament, not as a member of either house, but because no bill can become law without the President's assent. This structure ensures a comprehensive legislative process where decisions are made through deliberation and presidential oversight, forming the bedrock of our national lawmaking machinery. Similarly, at the state level, the Constitution provides for a legislative body for each state, as outlined in Article 168. This article states that for every state, there shall be a legislature, which shall consist of the governor and, depending on the state, either one or two houses. In states that have two houses, the legislature comprises the governor, the legislative council, or Vidhan Parishad, and the Legislative Assembly, or Vidhan Sabha. In states with only one house, the legislature consists of the governor and the Legislative Assembly. The governor, much like the president at the union level, plays a crucial role by giving assent to bills passed by the state legislature, thereby completing the legislative process within the state's jurisdiction. The composition of these legislative bodies is designed to reflect the democratic will of the people, while also incorporating a mechanism for reasoned debate. The Lok Sabha, or the House of the People, is composed of members who are directly elected by the citizens of India from various territorial constituencies across the country. This direct election makes it the primary chamber representing the popular mandate. The state legislative assemblies, or Vidhan Sabhas, mirror this structure at the state level, with their members also being directly elected by the people of that particular state. These bodies are the primary forums where governments are formed and held accountable, serving as the voice of the electorate in the day-to-day governance of the nation and its states. The second chambers, where they exist, serve a different but equally important purpose. The Rajya Sabha, or the Council of States, primarily represents the interests of the various states and union territories of India. Its members are not directly elected by the public, but are elected by the elected members of the state legislative assemblies, ensuring that the federal character of our polity is reflected in national legislation. Similarly, the legislative councils, or Vidhan Parishads in the states, are composed of members from diverse backgrounds, including those elected by local bodies, graduates, and teachers, as well as those nominated by the governor. This composition is intended to bring a wider range of expertise and a more deliberative perspective to the legislative process, acting as a revising chamber. Bicameralism, in its essence, is a legislative system that consists of two separate houses or chambers. In the Indian context, this principle is applied at the union level, with the parliament comprising the Rajya Sabha and the Lok Sabha. This dual-chamber structure is not a mere duplication of effort, but a deliberate constitutional design aimed at achieving specific governance objectives. The Lok Sabha, being the house of directly elected representatives, embodies the immediate will of the people and holds the government accountable through mechanisms like the no-confidence motion. Its legislative proposals are imbued with popular legitimacy, reflecting the current political mood and the mandate given by the electorate during general elections. It is the primary legislative body where most bills, especially money bills, are initiated. The Rajya Sabha, on the other hand, is conceived as the upper house or the Council of States. Its role is multifaceted. It acts as a check on hasty legislation passed by the Lok Sabha, provides a platform for sober and thoughtful debate away from the immediate pressures of electoral politics. And most importantly, it represents the interests of the states in the federal structure. Since its members are elected by state legislatures, it ensures that the unique concerns and perspectives of the states are not overlooked in national lawmaking. This system of indirect election also allows for the inclusion of eminent personalities with expertise in fields like science, art, literature, and social service, who are nominated by the president and can contribute their knowledge to parliamentary discourse. While bicameralism is mandatory for the Union Parliament, it is optional for the states. The Constitution allows states to choose whether to have a unicameral legislature, meaning only a legislative assembly, or a bicameral legislature, meaning a legislative assembly and a legislative council. Most Indian states have opted for a unicameral system, finding a single legislative house sufficient for their governance needs. However, a few larger states have adopted a bicameral structure. The rationale behind this choice often relates to the size, diversity, and complexity of the state, where a second chamber is seen as beneficial for providing a more comprehensive review of legislation and for giving representation to various professional and academic bodies within the state. The functioning of a bicameral system introduces a necessary element of delay and deliberation into the lawmaking process. A bill passed by the first house must be sent to the second house for its consideration and approval. This provides an opportunity to identify and rectify any defects, ambiguities, or unintended consequences in the proposed law. The Legislative Council at the state level, much like the Rajya Sabha at the center, cannot permanently block legislation, especially money bills, but it can delay it and suggest amendments. This power of revision and delay ensures that laws are not passed in a hurry or under populist pressure, leading to more robust, effective, and well-thought-out legislation that stands the test of time and serves the public interest more effectively. The Indian Constitution provides a unique and flexible mechanism for states to decide on the structure of their legislatures, specifically concerning the existence of a second chamber. This power is enshrined in Article 169, which outlines the procedure for the abolition or creation of legislative councils in states. Unlike the permanent nature of the Rajya Sabha at the union level, the Legislative Council, or Vidhan Parishad, in a state is not a permanent feature and can be established or dissolved based on the will of the state itself. This provision acknowledges that the need for a second legislative house may vary from one state to another and can change over time depending on political, social, and economic circumstances. The process for creating or abolishing a legislative council is a two-step procedure that involves both the state and the union. First, the Legislative Assembly of the concerned state must pass a resolution to this effect. This resolution requires a special majority, which means it must be supported by a majority of the total membership of the Assembly and by a majority of not less than 2/3 of the members of the Assembly present and voting. This high threshold ensures that the decision to alter the legislative structure is not taken lightly and has substantial political consensus within the state. It reflects a considered judgment by the directly elected representatives of the people of that state. Once the state legislative assembly has passed the resolution with the requisite special majority, the second step involves the Parliament of India. The resolution is then sent to the Parliament, which can then pass a law to either create or abolish the Legislative Council as requested by the state. Unlike a constitutional amendment, this law is passed by Parliament with a simple majority similar to any ordinary piece of legislation. This means that while the initiative must come from the state, the final decision rests with the Union Parliament. This process maintains a balance, giving states autonomy in initiating the change, while ensuring national oversight over the structure of state governance. This constitutional provision has been utilized by several states over the decades. For instance, states like West Bengal and Punjab have had legislative councils in the past but later chose to abolish them. Conversely, states like Andhra Pradesh have abolished and subsequently re-established their legislative council, demonstrating the dynamic nature of this feature. The debate over the utility of legislative councils continues, with proponents arguing they provide a forum for expert opinion and act as a check on the assembly, while critics often view them as an unnecessary financial burden and a tool for accommodating political figures who could not win direct elections. Article 169, therefore, provides a democratic and constitutional pathway for states to adapt their legislative machinery to their evolving needs. The Supreme Court of India has played a pivotal role in interpreting the constitutional provisions related to the powers and functions of Parliament and state legislatures. Through several landmark judgments, the judiciary has clarified the scope of legislative authority, the nature of bicameralism, and the sanctity of parliamentary proceedings. One of the most foundational cases is Kesavananda Bharati versus State of Kerala from 1973. While it's primarily known for establishing the basic structure doctrine, this case has, profound implications for legislative power. The court ruled that while Parliament has the authority to amend the Constitution, it cannot alter its basic structure, which includes principles like parliamentary democracy, federalism, and the separation of powers. This judgment placed a crucial check on the absolute power of the legislature. Another significant case that directly addressed legislative privileges is Raja Rampal versus Honorable Speaker Lok Sabha in 2007, often called the Cash for Query case. The Supreme Court upheld the power of Parliament to expel its members for misconduct, such as accepting bribes to ask questions in the House. The court affirmed that while parliamentary proceedings are generally immune from judicial review under Article 105, Clause 2, this immunity is not absolute. The judiciary can intervene if the proceedings are tainted by illegality, unconstitutionality, or gross procedural irregularities. This case established a delicate balance, preserving the autonomy of the legislature while ensuring that its powers are exercised in accordance with constitutional principles and natural justice. The relationship between the two houses of Parliament was examined in the context of money bills. Article 110 of the Constitution defines what constitutes a money bill and gives the Speaker of the Lok Sabha the final authority to certify a bill as such. In the case of K.S. Puttaswamy versus Union of India in 2018, also known as the Aadhaar case, the petitioners challenged the classification of the Aadhaar bill as a money bill, arguing it was done to bypass the Rajya Sabha, where the government lacked a majority. The Supreme Court, by a majority, upheld the Speaker's decision, but the dissenting opinions raised serious questions about the potential for misuse of this provision. This case highlighted the judicial deference often shown to the Speaker's certification, but also underscored the ongoing debate about the Rajya Sabha's role in financial matters. Furthermore, the Supreme Court has consistently reinforced the principle of federalism by delineating the legislative domains of the Union and the states. In cases like Esar Bommai versus Union of India in 1994, the court laid down strict guidelines for the imposition of President's rule under Article 356, thereby protecting the autonomy of state legislatures from arbitrary central intervention. The judgment emphasized that the power to dissolve a state legislature is an exceptional one and must be used responsibly. These judicial pronouncements collectively ensure that both Parliament and state legislatures operate within their constitutional boundaries, that bicameralism functions as intended, and that the fundamental principles of Indian democracy are upheld, safeguarding the balance of power. While the Parliament of India and the state legislatures are both built on the principles of parliamentary democracy, they differ significantly in their jurisdiction, powers, and composition. The most fundamental difference lies in their legislative domain. Parliament has the authority to make laws for the entire country on subjects listed in the Union List and the concurrent list of the 7th Schedule. In contrast, a state legislature can only make laws for its specific state, primarily on subjects mentioned in the state list and the concurrent list. In cases of conflict between a central law and a state law on a subject in the concurrent list, the law made by Parliament generally prevails, highlighting the federal structure with a strong center. The financial powers of Parliament are far more extensive than those of state legislatures. Parliament passes the Union budget, which allocates funds for national defense, railways, highways, and other central government expenditures. It has the authority to impose taxes like income tax and corporation tax across the country. A state legislature, on the other hand, passes the state budget, which deals with subjects like public health, agriculture, and local police. Its taxation powers are limited to state-specific levies such as value-added tax, excise on liquor, and property taxes. The financial autonomy of states is thus constrained by the broader economic framework set by the central government and the Parliament. There are also key differences in their powers related to constitutional amendment and emergency provisions. Only the Parliament of India has the power to amend the Constitution under Article 368, although certain amendments affecting the federal structure require ratification by at least half of the state legislatures. State legislatures have no power to initiate constitutional amendments. Similarly, the power to approve the proclamation of a national emergency or president's rule in a state rests exclusively with Parliament. These powers underscore Parliament's role as the guardian of the nation's constitutional and territorial integrity, a responsibility that transcends the purview of any single state legislature. Finally, the composition and scale of the two bodies are vastly different. Parliament represents the entire population of over 1.4 billion people, with the Lok Sabha having 543 elected members and the Rajya Sabha having 245 members. A state legislature represents the population of that particular state, which can range from a few lakhs to over 20 crores. Consequently, the size of a state legislative assembly varies, from as few as 40 members in some smaller states to as many as 403 in Uttar Pradesh. This difference in scale means that while Parliament deals with issues of national and international importance, state legislatures focus on local governance and regional development, making them more directly connected to the grassroots issues of their constituents. The principle of bicameralism, or the system of having two legislative houses, is a cornerstone of deliberative democracy in India, serving several vital functions that, really strengthen governance. Its primary value lies in its ability to act as a system of checks and balances. The second chamber, whether it's the Rajya Sabha at the union level or a legislative council at the state level, provides a crucial mechanism for reviewing, revising, and reconsidering legislation passed by the first chamber. This prevents the passage of hasty or poorly drafted laws that might be driven by populist sentiment or a temporary majority in the lower house. By introducing a mandatory pause and a second layer of scrutiny, bicameralism promotes legislative quality and ensures that laws are more comprehensive and robust. Furthermore, bicameralism significantly enhances representation by incorporating a wider array of voices into the legislative process. While the lower house, Lok Sabha or Vidhan Sabha, provides direct representation based on population, the upper house offers a different form of representation. The Rajya Sabha represents the interests of the states, ensuring that India's federal character is respected in national policy making. State legislative councils, with their unique composition drawn from graduates, teachers, local bodies, and nominated experts, bring diverse perspectives and specialized knowledge to the table. This really enriches the debate and ensures that legislation is examined from multiple angles, leading to policies that are more inclusive and considerate of various societal interests. Some states in India have embraced this model to reflect their size and diversity. As of 2025, states like Uttar Pradesh, Bihar, Maharashtra, Karnataka, Andhra Pradesh, and Telangana operate with bicameral legislatures. These states are among the largest and most populous in the country, and the presence of a legislative council is seen as beneficial for managing their complex administrative and social landscapes. The council acts as a forum for seasoned politicians and experts who may not be suited to the rough and tumble of direct elections, but whose wisdom and experience are invaluable. It provides a platform for detailed discussion on bills, away from the often polarized environment of the directly elected assembly. In conclusion, the importance of bicameralism in the Indian parliamentary system cannot be overstated. It's more than just an additional legislative layer. It's a fundamental pillar that supports thoughtful governance, protects federal principles, and broadens the scope of democratic representation. While the debate over the utility and expense of a second chamber in states continues, its role at the national level remains undisputed. By ensuring that laws are made with care, deliberation, and the input of diverse stakeholders, the two-house system reinforces the stability, maturity, and effectiveness of India's democracy, ultimately serving the long-term interests of the nation and its people.